Peace and love, black families. The Prince of Pan-Africanism, Dr. Umar Johnson, coming back at you again. Another video before I go to sleep. I want to give a shout out to the entire Bobo Shanti Rastafari family for inviting me out and showing me much love in Tasakani, South Africa. We had a great time tonight. Very great time. Good seeing all the Bobo Shanti Rastafari and all the brothers and sisters from Tasakani, South Africa who may not necessarily be a part of the Bobo family. Of course, I consider myself a part of the Bobo family. You know, the Bobo Shanti Rastafari, the Garveyites, revolutionary Pan-African nationalists, as I am. Shout out to Empress Ima for putting the tour together. I just took those 3 moringa and cayenne tablets, Queen Mother. Moringa and cayenne tablets that you gave me. And they nasty, but I took them so I could feel better tomorrow. Okay, my big sister Nafisa here, she visiting with me for a couple days, so we're going to take her tomorrow to visit the Apartheid Museum, one of my favorite museums in the whole world, the South Africa Apartheid Museum. We also going to take her to Soweto to visit the Winnie and Nelson Mandela home, and we're going to check out the Hector Peterson Museum too. So we're going to take care of all that. Tonight, I want to talk about a very, very, very important law for black parents, the Family Educational Rights and Privacy Act, which is a federal law that went into effect in 1974. 1974. So I want all the parents to pay attention to this because this is a very important, it's very simple, but it's a very important law for black parents, okay? So the Family Educational Rights and Privacy Act law is just that. It is a law that protects your privacy in school. It is a law that protects your privacy in school. In fact, I'm going to summarize the FERPA law according to 3 major rights that it gives you. So number 1, it gives you a right to privacy. That means what? That means that the principal nor the teacher can discuss your child's personal or academic or medical or family or juvenile information with anyone inside the school or outside the school unless they have written permission from the parents. You gotta have written permission from the parents before you can discuss a child's information. Academic, family, medical, you cannot discuss the child's information unless you have written permission from that child's parents, okay? So that's very important. So let's say that your child comes home and tells you, they say, Mom, I overheard my teacher telling another teacher about the fact that Daddy got locked up last week. Okay, now that's personal family information. Your son's teacher told another teacher that the father was locked up. How is that relevant to that child's education? How is it relevant for that other teacher who doesn't even teach your child? It's not relevant at all, is it? That teacher had no right to know that your son's father went to jail. And because his teacher told the other teacher personal business about the family that she did not have an educational need to know, that teacher can be written up. She can be reported to the State Department of Education, and she can be written up with an official disciplinary letter in her professional folder, which can affect her ability to get another job. And if it happens again, she could lose her job. Yes, teachers can be fired. Principals can be fired. Counselors, nurses, school psychologists, social workers, any school staff member can be fired or brought up on disciplinary charges for divulging a child's personal, academic, social, medical information, any information about the child or their family. You cannot discuss it with anyone else in the school or district unless that person has an educational need to know. Let me give you an example of something that's an educational need to know. I am a second grade teacher, and I had a child wet his pants in my class. He doesn't have a change of clothing, and we can't get in touch with the parents to bring him another set of clothing to the school. So I'm going to go and let the math teacher who's going to be with this child in the afternoon, I'm going to let the math teacher know that this kid may smell like urine and he might be kind of smelly, and some of the other kids might try to pick on him. So please look out for him. That was appropriate because the afternoon teachers have an educational need to know that this kid had a bathroom accident so that they can take the necessary precautions to look out for that child. Okay? I give you another educational need to know, possibly. This is possibly. A kid admitted that he or she was contemplating suicide. God forbid. That he or she was contemplating suicide. I'm concerned about that child. Okay? And of course, there's other things I need to be doing, like contacting the parent, calling the mobile crisis unit, coming up with a plan to get that kid to the crisis center so a suicide assessment can be done by the intending psychiatrist. But in the meantime, he has to go to another class. I'm going to let the other teacher know that you cannot let this kid out of your sight. Okay? Now, to be honest with you, I should probably stop right there. Don't let the kid out of your sight. However, I need the teacher to take it serious enough to do what I asked her to do. So I may have to tell her that this kid may be interested in self-harm. I shouldn't say suicide because that's a little bit too much information. That could be a violation. But I may let the teacher know that we have reason to believe that this kid might try to hurt himself. I'm not going to say suicide. I'm going to just say he might try to hurt himself. Okay? So that teacher may have an educational need to know because she's going to have that kid under her supervision, and she needs to make sure the kid doesn't do anything dangerous to hurt himself or to hurt herself. Okay, so that would be another example. So number one, they cannot discuss your business with anyone in the school who doesn't have an educational need to know. So that's the first of the major 3 protections that the Family Educational Rights and Privacy Act of 1974 gives parents in the United States of America. Okay? Number 2, okay, it gives you a right to a copy of your child's academic record, a complete copy of your child's academic record. So here's my question for all you parents. When is the last time you wrote a letter to your child's school principal requesting a copy of their complete academic record? Some of you have never requested a copy of your child's academic record. And do you know when this will come back to bite you? This will come back to bite you when you try to transfer that kid to a private school, or you try to get them put into a special magnet school or gifted school, you see, or you want to transfer them out to another school. That's when it comes back to bite you, because when you apply to these other schools and they deny your child and you say why, and they say because we read something in the record. We read something in the record that appears to suggest that your kid might be a behavior problem, or that he smokes marijuana or smokes cigarettes, or because the teacher wrote up a behavioral incident in such a way that exaggerated the facts and circumstances of the case. And so this is why you need to request a complete copy of your child's record. I recommend once every 3 years. Once every 3 years. Now, if you have a badass kid, you have a kid who's always getting in trouble, well, guess what? You need to be requesting a complete copy of your child's record every year or every 2 years, because your child's record is real thick. He got a lot going on. She got a lot going on. So you might need to request a complete copy every 2 years, okay? Especially if you're raising a black boy. You raising a black boy, or you have a child in a racist school district, you better be getting a copy of that record, because teachers can put whatever they want in there. Principals can put whatever they want in there. So you need to get a complete copy of that record so you know exactly what is inside your child's academic folder. Do you understand? So this is how the letter should read. This is just a sample. You can write it up any kind of way you want. Okay? Umar John, good afternoon. To whom it may concern, to Principal so-and-so. I am requesting a complete copy of my son, Umar Johnson's academic record to include all special education, behavioral, classroom, testing, and any other information that contains his name. I understand that this is my right under the Family Educational Rights and Privacy Act of 1974. I understand that you have 45 days to reply to my request. Please let me know if there is a cost associated with my request. If you have any questions about my request, I can be reached by telephone or email by way of this information. And please let me know when my request will be granted, when I can pick up the copies. That's all it is. One paragraph, 3 or 4 sentences. I'm requesting a copy of the records. This is my right under FERPA 1974. Please let me know if there's any costs associated with it. I understand that you have 45 days to respond. Please let me know when I can pick it up. That's it. Okay? That's all you have to do to get your child's records. Okay? And then when you get your child's records, you want to go through them with a fine-tooth comb to make sure there's nothing in your child's academic record that can negatively reflect upon your child or misrepresent them in any way. Okay? Now, the FERPA law, okay, also gives you a right to challenge or contest any documentation in the child's record that you don't agree with. So let's say after you get the record, you go through the record and there's a pink slip that Miss Slurbanowski wrote up on little John John. And it made it look like John John tried to beat her up when all John John did was try to get past her on his way out the door because he didn't want the situation to escalate. And he knew that the teacher was trying to provoke him. So he decided to exit the classroom and go straight to the principal's office. Now, on his way out the door, Miss Slurbanowski stood in John John's way and tried to block his access to the hallway. But when she wrote up the pink slip, she made it look like he pushed me, he threatened me, he hit me. You know, white people, they love to exaggerate on our kids, right? Let's just be honest. So you see this pink slip and you say, oh, hell no, this is not what happened. What should you do? You write a letter to the principal and you carbon copy the superintendent, or you can carbon copy the assistant superintendent, or you can carbon copy the regional superintendent, or you can carbon copy the school district director of discipline. But you need to carbon copy someone from central office. Always carbon copy someone from central office, okay? And you say, I have received a copy of my child's record. I have reviewed the record. There's documents in here that I believe are inaccurate, misleading, and that negatively reflect upon the character of my child. I have a right under the Family Educational Rights and Privacy Act of 1974 to challenge any documentation in my child's folder that I believe to be inaccurate. And you are obligated to have someone hear my complaint, okay, and determine whether or not I have sufficient grounds to have this documentation removed from my child's record. Okay? So, with that being said, you can get anything taken out of the record. And guess what? You might need to find some witnesses. You might need to find some people who can attest to your version of the story. Because guess what? The teacher involved may no longer work at the school. The principal involved may no longer work at the school. So you need to find people who were there. Students, teachers, parents who can attest to exactly what happened to substantiate your argument that this documentation needs to be removed out of your child's record. Okay? So you have a right to the record. You have a right to contest anything in the record, and you have a right to privacy. Okay? So this is very, very important. Y'all need to be getting copies of those records, okay? Very, very important that you get copies of your child's record, because you don't know what is in that folder. And there's certain things you do not want sent to the new school from the old school. And there's certain things you don't want the potential receiving school, okay, to get their hands on, especially when it's not true about your child. So make sure you get a copy of the record every 2 to 3 years, okay, every 2 to 3 years, and definitely before you transfer your child to another school, especially if you're trying to get them in a major school, high achieving school, magnet school, college prep school, private school. You don't want your child being turned down because there was information in the record that wasn't accurate and you didn't get it in time in order for you to challenge that documentation. I'm thinking about putting together a workbook for parents that has samples of letters that you can write to the school. Do y'all think that would be a good idea? I'm thinking about doing maybe 20, 25 letters in a packet, okay, a workbook that you can buy to go along with psychoacademic Holocaust, so you can see how you can actually present yourself in your case, in your argument to the school. Okay, so I'm going to be working on that, you see. And because this is FERPA, it's not special ed, it's a federal law. Special ed is a federal law too, but FERPA is a law, not a program, whereas special ed is a program. FERPA is a federal law, so private schools have to honor FERPA too, just like we talked about earlier. Private schools have to honor the 504 accommodation plan also. Okay, and as I do some of these videos, I'm gonna have to, it's only once I only seen one, but I'm gonna have to delete some people, because the video I did earlier about the 504 plan, one of the sisters came on there and made a post, and she didn't know what the hell she was talking about. She said something about special ed is for accommodations. Special ed is not for accommodations. Special ed is for children with disabilities who need specially designed instruction. Special ed is not for accommodations. It is for instructional modification. But you don't know that because you don't do this, but you want to come on my posts and act like you know more than you don't. Now, if the child is in special ed, they can get accommodations. There is an accommodation page on the IEP. If you watch my whole video from this morning, you would have heard me say that, but you were too busy trying to look smart on my posts that you made no sense. Special ed is not for accommodations. It is for instructional modification, but you can get accommodations in special ed because there is an accommodations page on the IEP. You don't go to special ed for accommodations, but you can get special ed while you are receiving your instructional modifications. Okay? While you can let me say that again. You can get your accommodations while you are in special ed receiving your instructional modifications. So for example, you go to the supermarket, right? And you go to the supermarket to get you some ice cream. But while you in the supermarket, there was something else you saw that you want to get. You didn't go to the supermarket for ice cream. Excuse me. You went to the supermarket for ice cream. And then you saw something else that you wanted. Let's say a magazine. There was a magazine that you wanted to get. So you went to the supermarket for ice cream. But while you were in the supermarket, you saw the magazine. So you end up buying the magazine with the ice cream. But you did not go to the supermarket for the magazine. You went to the supermarket for the ice cream. That's how it is with special education and accommodations. You go to special ed because you have a disability that requires specially designed instruction. Specially designed instruction is a modification of the regular ed curriculum. It's a modification. You're changing the instruction. It's a modification, Mrs. Know-it-all. Okay, so you go to special education because you need instructional modifications. But while you are there, it may be determined that you need accommodations on top of your modifications. Special ed is for instructional modification, but you might need accommodations on top of the modification, if that makes sense to everyone. Okay? Your purpose for being there is you have learning problems, but you might need accommodations so you can adjust in school while you are there. Now, it's true. If a child is diagnosed with an emotional disturbance, okay, They go to special ed for an emotional disturbance, which is the only category of special ed that doesn't speak directly to instruction per se, along with autism and some of the others. But it's the main special ed disability that deals with emotions and behaviors that is really not instructional per se in essence. But guess what? Even with an emotional disturbance or ADHD for other health impairment, you cannot receive special education unless the emotional disturbance or the ADHD is adversely affecting your educational performance. That's right. It has to affect your educational performance. So even if you're going to special ed for emotional disturbance, you better have a need for some degree of instructional modification, because if you don't have a problem learning and you have an emotional disturbance, you should not be in special ed. You should have got a 504. I'm going to say it again. If you do not have a problem learning, if your emotional disturbance is not affecting your ability to learn in the regular class, you should not be in special education. You should have got a 504. Special ed is for children with disabilities that affect their ability to learn. And because the disability affects their ability to learn, they need instructional modifications in the special ed setting or in the regular ed setting with the special ed teacher. And as I said earlier, special ed is a program, not a place, so the child can stay in the regular class and receive their special ed help. A child can stay in the regular class and receive their special ed help. Okay? And remember, if your child is in special ed full time, we got a lawsuit. If they not blind or deaf or profoundly retarded or autistic and they in special ed all day, we got a lawsuit. Okay? I agree with you, Sister Erica. You said we need a book to teach teachers how to interpret these IEPs. I agree with that. A lot of teachers don't really know what the hell is going on. Okay, but I don't really blame them. A lot of them are not being told by their principal. Principals aren't honest with teachers either because they got hidden agendas to get rid of kids and other things like that. Okay, so, I don't want to beat up on our teachers because we got a lot of good black teachers. In fact, most black teachers I know, most black teachers I've worked with, most black teachers I've supervised were really, really good. Really, really good. I even know some good white teachers. I'm not even going to lie to y'all. I know some good white teachers. Now, do I want black kids being taught by white folks? Hell no. But I do know some good white teachers, okay? But I also know some trifling ass black teachers. Oh, I know some trifling ass black teachers. I wouldn't put nobody's kid. I wouldn't put the child of my worst enemy in front of some of these Negroes. They could care less about a black kid. They come to school to get paid so they can go get their Louis bag and go to the Puff Daddy concert. They ain't thinking about properly educating no children, okay? Now, as far as autism, I'm going to do a whole video on autism. Okay, now this is what I'm going to do. This is what I'm going to do because I went over FERPA. It's not much to FERPA. I'm going to end this video right now and I'm going to come right back because I want to do a video on manifestation determination for special ed kids who have been charged with serious behavioral infractions. Okay, so we're going to do manifestation determination in about 5 minutes. I'm going to drink some more of this orange juice, do manifestation determination, then I'm gonna go to sleep because me and Nafisa got to leave 10 o'clock to go to the museums tomorrow, and I want to fall asleep watching Barry Gordy's The Last Dragon. Okay, I'm gonna just be honest with y'all. I want to play The Last Dragon in The Last Dragon remake. You feel me? I want to be Timac. I want to be The Last Dragon. Rest in peace to Vanity. I know let me see, who do I want to play Vanity when I play The Last Dragon? Okay, because I'm going to do The Last Dragon. I'm going to get in shape. I'm going to get buff. I'm going to get all that. I'm going to be The Last Dragon, okay? Now, who do I want to play who I want to play Vanity in The Last Dragon? Let me think. Who I want to play Vanity in The Last Dragon? Who I want? Jill Scott. I like Jill Scott. Shout out to her and her husband. She's married. I was going to try to marry Jill Scott, but he got her first. North Philly in the building. Blessings to her and her king. May God bless the marriage. I don't know who I want to play Jill Scott. Megan Good is kind of skinny, and but she's fine. Megan Good is fine though. Megan Good is fine, but who out there? Who out there? I need an African-centered sister with a nappy head, cause y'all know I love nappy-haired women. Okay, who gonna play Jill Scott? Okay, Fran, you gonna play Jill Scott? Okay, Fran says she gonna be, Fran gonna play Vanity when Dr. Umar does the Last Dragon remake. Okay, so I will be back in 5 minutes, but I'm going to fall asleep watching The Last Dragon. And if I'm not asleep by the time Last Dragon go off, I'm probably going to watch Barbershop 3. Okay, shout out to the whole Barbershop 3 team. Ice Cube, you need to get me in a cameo on that Barbershop 4. I need to come into the barbershop and drop some major knowledge. So all my West Coast Pan-Africanists, tell Ice Cube he need to get Dr. Umar to do a cameo in that Barbershop 4. So I'll be back in 5 minutes so we can do manifestation determination.